mean, it's very difficult post the hearing. You can't go and make a request to the judge that you pass the order early. It's going to be very difficult. Only role you would have is go to High Court and say that the order has been passed very late and these are the issues. But then there might be some other issues or consequences because of that, right? So you can't go and tell the tribunal that pass the order early. From the ITT bar, generally there could be requests which have been there, especially ITT Mumbai bar and all are very active. They're all 60, 70 years of history. So they will, generally these kind of situations should be collectively raised through the associations that these matters should be fastened. But individual cases, going and making request may be practically very difficult. Only thing is you'll have to go to High Court if there is a substantial delay. Next we come to the additional evidence. Again, a critical aspect that has to be kept in mind while in the income tax proceedings, Rule 29. Now, what is additional evidence? An evidence which has not be presented or part of record of the lower authorities. You have not given it to the assessing officer, you have not given it to the CIT appeals. Okay? So that is a new factual data which is now there, which you want to produce before the tribunal. Case laws, government orders, government records, public records are not additional evidence. By virtue of the rules, like for example RTI is not an additional evidence. You get an information RTI, it is not an additional. For example, you file an RTI to get an file notings, that is not an additional evidence because it's a part of government record. So those are not additional evidence. Under section 74 of the Evidence Act, any government record is a public record. That means it is outside. I mean, it is known. It is not an unknown record. So, if apart from that, if you have anything to submit, then Rule 29 has to be kept in mind. That additional evidence has to go as per Rule 29 read with Rule 18.4. Now, Rule 29, what it says is that the parties to the appeal shall not be entitled. See, it is drafted in negative terms. It doesn't say he shall be entitled if these conditions are satisfied. He says shall not be entitled to produce additional evidence, either oral, documentary before the tribunal. So first limb says you are not entitled. But if the tribunal requires, so it is a discretionary power given to the tribunal, complete discretionary. You look at the negative language of the starting limb, he shall not be entitled, that means you are not entitled. But if the tribunal requires any document to be produced, any witness to be examined, any affidavit to be filed, or to enable it to pass orders. That is the first part of the second limb. Second part, or for any other substantial cause. Third part, if the income tax authorities have decided the case without giving sufficient opportunity to assessee to adduce the evidence either on points specified by them or not specified by them. Okay? So this is the third part. So first situation is assessee is not entitled. Second situation is tribunal may permit filing of additional. Three circumstances. One, there is requires the tribunal itself require the document for which enable it to pass the orders. The tribunal itself writes a request so that it wants this document to pass an order, then you need not file an additional evidence there. The tribunal is asking, you are giving. Okay, then it is not a case which falls in part 3 of this limb. Then it says, or any other substantial cause. The third one, if the income tax authorities have decided the case without giving a proper opportunity to the assessee or to adduce. So when you want to file something, right, it will have to come in this third part, right, that I wanted to file this, either I did not get this notice, or the addition was directly made in the assessment order, no show cause notice was issued to me, or this document was not with me, I had to collect it from third parties, this document with was some government authorities, I could not collect it, or this document was attached by someone. So there could be again n number of reasons why you want to do it. Okay. Rule 18.4 says that when you want to file an additional evidence, you should file a separate paper book. Rule 18.4 says when you want to file an additional evidence, you should file a separate paper book. Paper book is, you understand paper book? Which in the tribunal, before tribunal will file a paper book that these are the records before the lower authorities and this is I am filing for the information of the tribunal. Now if you want to file a additional evidence, you should file a separate paper book, index it accordingly along with a petition for along with the admission of additional evidence. Okay. So 18.4 says you file a separate paper book, also file an application for admission of that additional evidence. Now, where in that petition you will have to explain that why I could not furnish this information before the assessing officer, before the CIT appeals. These are my reasons that why I could not furnish, and now you make a prayer to the tribunal, kindly admit this additional evidence and take it on record for the purpose of disposal of the appeal. After you make an application, the discretion is still with the tribunal. Tribunal may say, I will not accept it, your reason is not valid. Again, I will say they are liberal, they will generally admit the additional evidence, but again you need to have a sufficient cause. It doesn't mean because they are liberal, we all file all documents before the tribunal. We should make an effort to file it before the assessing officer, build the case from the roots, from the bottom, and try to give the information to the assessing officer as much as possible. Then it becomes very easy before the tribunal. Okay. If you have not done that for sufficient cause, then you can always furnish it before the tribunal. Tribunal will be liberal to accept the additional evidence, but you need to have follow the procedure and make an application to the tribunal that there is a sufficient reason for me to file this, sufficient reason for not being able to file before the assessing officer. Then the tribunal, last limb of the rule 29, tribunal for the reasons recorded may allow such documents to be produced or witness to be examined or affidavit to be filed and may allow such evidence to be adduced. So tribunal's discretion. Please also keep it in mind that once you have filed the additional evidence, the tribunal cannot say, I will not admit it. So the tribunal cannot ignore it. They will have to either accept it or reject it. They have to say, if they reject it, they will have to pass an order. In their order, they will have to say why they are rejecting it. They just cannot ignore it. That is not possible. Supreme Court's decision in Jyotsna Suri's case. Okay. So they have to come out saying that either we are accepting or either we are rejecting with so and so reasons. The issue, if you look at the language of 29 independently, the issue would generally arise that whether assessee suo motu can file an additional evidence or only when the tribunal requires it. But if you read 18.4, 18.4 says assessee can file a separate paper book for the purpose of filing the additional evidence. And always file a written application for admission of additional evidence. There is a decision of tribunal in Mascon Global, I am not cited here, which said that Mascon Global says even an oral request for admission of additional evidence is sufficient. They are reading rule 29. Rule 29 nowhere says that you should make an application for admission of additional evidence. So the tribunal in Mascon Global took a view that even oral submissions, it is 133 TTJ 257, Mascon Global 133 TTJ 257, said that even oral application for admission of additional evidence is proper. But my personal opinion, if you read 18.4, which very clearly says that you should file a separate paper book along with an application for admission of additional evidence, therefore to that extent Mascon Global's decision may not be correct. If you want to file a petition for additional evidence, in those cases please file an application along with proper index and documents what you are filing along with sufficient reason why there is a delay. Now we come to 254.2. So this is another section 254.2 and the provisos. 254.2 deals with the mistake apparent from record. Now 154 we all know, the assessing officer passes an order. If he finds that there is a mistake apparent from record, he can rectify it. So the concept of mistake apparent from record is very simple for us, we understand it. Same power has been given to tribunal in 254.2 but slightly differently worded. The appellate tribunal may at any time within 6 months from the end of the month in which order was passed. Look at this time limit, 6 months from end of the month in which the order has been passed. Earlier it was 4 years, in 2016 they reduced this 4 years to 6 months. For assessing officer 4 years, for tribunal 6 months. Clear discrimination, but anyway that is how it is. So 6 months from the end of the month in which order has been passed, with a view to rectifying any mistake apparent from record. This term we clearly understand. It should be a patent mistake, blatant error which comes from the record. But keep it in mind what is record here. What is record for the purpose of income tax appellate tribunal? Appeal memo, paper book. Is entire paper book a record? The rule says what you have referred is a record. You file 3000 pages, out of that 30 pages you refer during the hearing, only 30 pages is the record, not the entire paper book. The rule says that they define what is record, and record means what you have, I think rule, don't remember the rule, I think 18.6, yeah, 18.6 says that record means what has been referred, and what has been referred and referred and there's one more word used, relied, referred and relied during the hearing is record. So if you then file a 254 saying to something which you have not referred and relied, they say this was never argued before us, therefore we dismiss the 254 application. So therefore the important aspects, either you argue clearly referring to each and every page, or file a small brief synopsis written submissions before the tribunal saying that this is what, these are the documents, these are the pages, these are say the sale date, this is this I want to rely, this is what I want to rely, very clearly bring out. If you don't bring out that, if a point is missed, then in that cases the tribunal will be within their limits to dismiss your 254 application. They will say this was never referred and relied, therefore I will reject it. Yes. They do the file notings. As you argue, they would do the notings in their register. Okay. Now you can say that some of the judges don't do it, some of the judges miss it, that is there. So that is why file a written synopsis, a small synopsis, 3, 4, 5 pages synopsis, where you want to refer at least the important pages what you want to rely. That would be good practice for you if in some reason something is missed out one, or tomorrow you want to take the matter to the High Court that see I relied this, but tribunal has given a contrary view on the facts and therefore its order is perverse. You can take it. You can ask for a copy. There is a rule for that. You have to pay the fees for that. I think it is 10 rupees per page. You file that and ask for a copy. Their registers, I don't think they give, but file memo they will give. Register, to my knowledge, they don't give. So there, what happens is, so again, it should be mistake apparent from record. Mistake apparent we all understand. It is the something which is patent, glaring, and you can't, something which you can't, if you have to enter into an argument for a particular thing to demonstrate, that cannot be mistake. If you enter into an argument for a particular thing, that cannot be mistake. That cannot be taken into consideration. Classic decision of Balram versus Volkart brothers, T.S. Balram IT versus Volkart brothers, 82 ITR 50, both for 154 and 254, you can refer this. You can file a 254 petition. That is a mistake apparent from record. Demonstrate that entire thing is so and so. Last line inadvertently, instead of saying allowed, they have said not allowed. Okay. Now, once you say that there is a mistake apparent from record and file this petition for mistake apparent from record, in those cases, the tribunal, so for example, what is a common mistake we will see, that some ground is not disposed. You take 10 grounds, they dispose only 8 grounds. One particular issue is not disposed. Then you have to file a 254 application that look, my 10 grounds were there, I argued on these 10 grounds and 2 grounds you have not disposed. Therefore, there is a mistake apparent from the order. Kindly recall your order to the extent of these 2 grounds. So when the MP is heard, they will find that there is a merit in your arguments. They will recall the order to the extent of 2. But in the MP order itself, they will not decide on 2 grounds. The MP order or the order under 254.2, MP or MA, whatever you call it, is restricted to whether there is a mistake apparent from record or it is not mistake apparent from record. The arguments on merits will be separately heard and a separate order will be passed. So in this kind of a situation, there could be 3 orders. First, an order has been passed. You find a mistake in that order. You file a miscellaneous petition, tribunal accepts that mistake, that is the second order. Then suppose 2 grounds were not disposed, they will hear that 2 grounds separately and they will pass one more order saying that these 2 grounds we are deciding in so and so manner. So effectively there will be 3 orders, which you have, cumulatively, which have to be combinedly read for giving order, giving effect to. So this is another thing which you have to keep in mind. Tribunal does not have power to review. Power to review is generally only with the, See, ideally the tribunal rules say they should decide all the grounds, the judicial precedents say they should decide all the grounds, but in many times we will find that this kind of a situation will be there. There are legal grounds are in assessee's favor, so alternate arguments are not taken. Even if at a practical level, even if you make a request, they may say anyway this is in your favor, why you want to argue this. In those cases, only recourse could be to go to High Court if you really want to pursue those other grounds. Second recourse will be if the department files the appeal on the legal grounds, and if the legal grounds goes against you in the High Court, then the grounds on merit you will have to ask High Court to remand it back to the tribunal to hear on merits. This is something which you have to take care in the High Court appeal. If you miss out that and only legal ground is upheld, if there is no your appeal, then it goes into the revenue's favor.
If there is no department appeal, can I file an appeal in High Court asking the tribunal to adjudicate on the merits?
You can file, but it will not serve any purpose, because if the department doesn't file, legal ground is in your favor, the matter is as good as closed. So no doubt you are aggrieved by the order, you can file, but again the tribunal's statement that it is only academic will become true, because there will there is no monetary effect for you, and no assessee will pay or a client will pay fees for that kind of an appeal.
But what if the legal ground is reversed in somebody else's case?
Unless there is the appeal in your case, they can't do anything about it. There has to be appeal in your case, right? If there is no appeal, say 147 is cancelled in your case. Now, some similar matter, some appeal has filed, it is reversed by someone else, doesn't mean in your case it will get reversed. Your appeal, what is the decision? They have to file an appeal to High Court if you want to reverse in your case. Yeah.
Sir, if the nil, that's what you call tax neutral citation is given, whether if I take view A, agricultural income, or view B, PGBP, both the way my tax addition is 0 only. But because this case can be taken as a hold for next
Precedent for subsequent year.
should,
You should go and see, it depends on client to client. If client will say that I don't want to pursue it because of the cost of further litigation. But if it is a successive years is a similar issue, you can pursue that. You can pursue that further to the higher forums, wherever it is you can pursue it. Now, the time limit of 6 months may create problem at many times. Now, it says, look at the words, 6 months from the end of the month in which order has been passed. Now, first question is the time limit from 6 months which order has been passed. Now, if you see the entire section 254.2, 2 to 3 interesting issues arise. Now, suppose first issue is you file an application. You file an application within 6 months, but tribunal doesn't pass an order within 6 months. What happens? Can it pass an order after 6 months? Yeah. Again, we will say that tribunal is constituted for doing justice, so that should be there. But in the context of some earlier 4 years, as well as in the context of 154, the Supreme Court's decision is there cited on page 118. You can use this both for 154 and 254. Sri Iyengar Spinning Wheels, that if the assessee has filed the application within time, so at that time it was 4 years, now it is 6 months, the tribunal can still pass an order after 6 months. And the similar thing is there in case of 154, CBDT Circular 73, 7th January 1972. In both these cases, they have taken a view that in the case of context of CBDT Circular, if you file a rectification application within time, they can still pass an application after 4. Because if you see even 154, the order should be passed within 4 years. It is not the application should be filed. So effectively, by virtue of Supreme Court's decision in CBDT Circular 73, you can say that this time limit of 6 months is for the outer time limit for you to file the application at least. Okay. Now, once you have filed an application, will it be 6 months from the end of the month in which order was passed, or will it be 6 months from the end of the month in which order was received? The language very clearly says passed, right? The language of 254.2 very clearly says 6 months from the end of the month in which the order was passed. Unfortunately, when they amended it, this made it link the time limit from the month of which the order has been passed. That was also earlier, because earlier it was 4 years, it was okay. Even in 154, it is 4 years from the end of the year in which it has been passed, so that was still okay. But now they have said that it is 6 months because of itself very short time. At least nowadays you get the orders very quickly, they post it very quickly, sometimes it's uploaded on the, most of the times it will be uploaded on the tribunal website, so you'll be able to access those orders and look at it. But there could be circumstances where suppose there's an address change and it has not been intimated to tribunal, order does not come. There could be various reasons why the assessee may not got the order. There was an unfortunate decision of Hyderabad Tribunal cited at page 18, Shashidhar Chaganti's case. They said the expression from the end of the month in which order is passed could not be interpreted from the end of the month in which order is received. Tribunal accepts that the delay was because it did not post the order. And still they said we will not accept this MA. Unfortunate decision. But footnote 21, page 19, subsequently various high courts and tribunals have taken a view that 6 months should be taken from the time in which order has been received. So courts have come to the rescue to read the language which has been passed to received in 254.2. Again, I am not suggesting use this, try to file it in time if you want to file it 254, but in situations where you may not get the order or there could be some circumstances where this has not happened, at least 6 months from the received can be taken based on these particular decisions. Rule 35A deals with how the miscellaneous petition will be heard, 35A of Income Tax Appellate Tribunal rules. And as per this, the application what you file should clearly and concisely set out the mistake which you want to rectify. What is the mistake should be clearly stated in the application. The application should be filed in triplicate and the same way the appeal has been filed. How do you file the appeal? Same manner it has to be filed, signed by so and so, tribunal order should be attached. There is a 50 rupees filing fees for miscellaneous application, 50 rupees is the MP fees which has to be paid. The miscellaneous petition will generally be heard by the same bench which passed the original order. So there is a combination of say Mr. A and Mr. B who has passed the original order. Then the miscellaneous petition, which is this rectification application, MA or MP, whatever you call, should be heard by the same members. It should not be heard by the other members. In a scenario where that member has got transferred or something else, then the president or vice president can nominate some other person. Because only that person can know what he has written in the order, for what purpose he has written in the order. No one else can go into his mind and understand his order. Therefore, the rule 35A says same person should ideally hear the MP and then adjudicate on the MP. Next issue that arises, can there be MA on MA or MP on MP? Whether you call MA, MP, it is one. That means order is passed, you file a miscellaneous application. In miscellaneous application order is passed, there is now mistake in that miscellaneous application order. What will happen? Can you file another? Look at the language of 254.2. What does it says? With a view to rectifying any mistake apparent from record, amend any order passed by it under subsection 1. What order they can amend? Now this order, MP order, is passed under subsection 2. The main order was passed under subsection 1. It is unlike 154, you can rectify a rectified order also. But under 254, you can't file a second MP against the MP. You can file an MP against the main order. But if there is in a first case situation, mistake in the MP order, then you can't file another MP against the MP order. Because the language says, what can be rectified is the order passed under subsection 1. The order passed under subsection 1 is only the appeal order, first order. The MA order is passed under subsection 2, which is not rectifiable. If an unfortunate situation of that kind comes, then in those cases, you will have to go to a writ petition to the High Court. Right?
Sir, if there are two rectifications to be done in
Suppose you have original order, mistake 1 you filed first MP, then mistake 2 you file a second MP. Right? This is the question. Ideally don't do it. Not good for you also, and for the assessee also, he has to pay fees twice. If you file a second MP, in that second MP you will have to give reference to the first MP that this was already filed, this is what has happened to that, can be done. Again, it should be a mistake in the original order, it should be within 6 months, all that should be satisfied. There is no bar in filing second MP. Practically, we would not suggest to do anyone that. But if that kind of circumstance is there, you can do it. In the second MP, give reference to first MP. Rule 35A very clearly says you should give reference to that all in the second MP also. Okay?
Can we add additional ground?
No. See, we are talking of mistake apparent from record.
Additional evidence in MP.
We are talking, is it record? It should be record. See, first paper book itself may go out of record if you have not relied and referred. Now you are talking of filing an additional evidence. Then you will say, I will file one more additional evidence. That will be stretching too much.
In the case of MP, sir, there are three orders. First one being the original, then MP order, then the amended order. I agree we cannot file the MP against
Amended order you can file.
Yes, sir.
Because it is still a 251 order, 254(1) order. You can file against a 254 order. You can file an MP against a stay petition. Stay petition order is an order under 254(1). You can file MP against that. But MP against MP is not permissible because the subsection 2 says order under subsection 1.
Indirectly it's permitted.
No. Not that way. Suppose in the MP order there is a mistake. You have filed an MP saying that this ground is not argued. This ground is not adjudicated. Tribunal in the MP order says we have adjudicated this ground. Now this is a mistake in the MP order. You can't rectify that mistake. You will have to go to High Court. Next we come to stay petition 254 2A. This has a checkered history, too many changes, because tribunal naturally, the income tax department naturally, when has raised the demand, want to show some collection. There is a issue of target of collection, lot of things, where the officer would like to collect as much as possible. Okay. As we saw in the earlier part of our discussion, Supreme Court in Mohammad Kuni's case clearly said that tribunal's powers are very vast, it can decide the stay petition. 254 2A first main subsection is not of a much use. It says you should pass an order within 4 years. It's a directory thing. Generally 4 years is long time, at least now they pass much faster than that. There was a time where pendency was high, but now things have improved. Okay. 3 provisos are what created trouble for us. So Mohammad Kuni's case gave unfettered power to the tribunal to decide on the stay petitions. So there were circumstances where if we demonstrated that it is a good case, tribunal would give you 100% stay also. They might have asked demand in certain cases, but if it was a good case, covered matter, we know that in the same they generally been liberal to grant you stay. This naturally would have troubled the department, saying that look here, they are giving a stay. In many of the stay granted cases, what used to happen is, used to prolong. So the rule says that if there is a stay granted matter, that should be given priority and it should be heard on a priority basis. So if anyone has seen the cause list of tribunal, they will put the stay granted matter on the top. They want to hear it at the first. Because this is a stay granted matter, tribunal has thought it fit to grant a stay, so they want to dispose it at the earliest. Okay. Despite that, there used to be delay. Generally when the first stay is granted, max of 180 days it is granted. And then if it in 180 days for some reason the matter could not be disposed, for whatever reasons it could not be disposed, then you file an extension application and get it extended further. Okay. What then it can, the second proviso says that it can be extended up to 365 days. So from your stay petition to 365 days, you get the protection from collection of the demand. Because once the department has, a tribunal has given a stay, naturally the assessing officer cannot ask you the payment for that against that amount. Okay. Now this 365 days came. There were cases where this 365 days also used to get breach and the matters would get prolonged further than that also. Okay. The provision was inserted, third proviso, that if the appeal is not disposed within this band of 365 days, in those cases the stay is deemed to be vacated. Then if you see page 21, first there, deemed to be vacated after the expiry of such periods, even if the delay in disposing of the appeal is not attributable to the assessee. What does the word says? Even if the delay is not attributable to the assessee. Suppose it comes for hearing 6 times and all 6 times department takes adjournment, then should not the stay be extended before 365, beyond 365 days is also then issue which had to be considered, right. So the department said that even if the delay is not attributable to the assessee, max period for which the stay can be granted is 365 days. This is what the department brought in by virtue of this third proviso, the legislature brought in by virtue of this third proviso. Okay. Now this particular limb, even if the delay is not attributable to assessee, was a subject matter of challenge. Now, naturally, you cannot challenge this before the tribunal. When the matters were heard before the tribunal said we are bound by 365-day rule, we cannot extend beyond that. Okay? But the high courts, Bombay High Court in Narang's case, Tata Communication, and the main decision, Pepsi Foods case, cited on page 21, there are various other decisions which said that these words, delay not attributable to the assessee, are arbitrary, unreasonable, discriminatory, and these were struck down. Pepsi Foods case says these words, even if the delay in disposing the appeal is not attributable to assessee, then the is arbitrary, unreasonable, discriminatory, and these words were struck down from the statute. So that decision holds field. There are various high court decisions which have concurred with the view taken by the Delhi High Court. Okay. If the delay is attributable to the assessee, that means you file a stay petition and you don't appear on the date of hearing. You take adjournment, you don't file paper book, you don't file records, you don't appear. In those cases, the tribunal can vacate the stay. That assessee is not cooperating in the proceedings, but he is taking the stay, we will vacate the stays. But if the delay is not attributable to assessee, even now the stay can go beyond 365 days. By virtue of Pepsi Foods decision and various other decisions, this principle is settled. Okay. Now, this was what was prevailing. Then the amendment was made in first proviso. Now, what does the first proviso says? That if the tribunal is considering the application of a stay, it should consider on merits and it should grant not more than 180 days. 180 days, first proviso can be extended to 365 days, second proviso. But the condition for granting max of 180 days is the assessee should pay 20% of, subject to the condition that assessee deposits not less than 20% of amount of tax, interest, fee or penalty or any other sum payable under the provision of this act, or furnishes a security of equal amount in respect of so and so. So now what has happened is, by virtue of this amendment, the tribunal hands are bound. If the demand is 100 rupees, if you file a stay petition to tribunal, earlier you could have argued that I will not pay 20 also, I will pay only 10 or I will only pay 5. Okay. But now the tribunal will say either you pay 20, not less than 20, so minimum 20 you pay, or give a security, bank guarantee to the extent of 20. If you satisfy this condition, then only we can grant you stay. Now, can the tribunal reduce this amount? Can the tribunal reduce this amount? Recent decision of Hindustan Lever Limited, Mumbai Tribunal, they said this is now in the statute, we can't reduce this amount. If we have to challenge, this is now a provision in the statute. Constitutional validity of this provision will have to be challenged, that subsection 1 which gives unfettered power as it thinks fit. Supreme Court's decision Mohammad Kuni, you are trying to override by bringing this 20% condition. Therefore, this 20% condition may be unconstitutional, and therefore, if you want to challenge, you will have to challenge it through writ petitions to the high courts, and high courts will say that 20% is correct or not. Okay? Because see, if you look at CIT appeals, there also the rule is 20%. But PCIT can reduce it less than 20% if certain conditions are satisfied. When PCIT can reduce, you are saying tribunal cannot reduce. That becomes a sort of a discriminatory, which is incorrect, which could be challenged. Now, the statute providing 10%, 20% in the case of indirect taxes has been upheld. There it is a pre-deposit, here it is not a pre-deposit. Again, don't confuse that this is a pre-deposit. This is not a pre-deposit. You file the appeal, you can file the appeal without paying this amount. Whereas in indirect taxes, you have to pay the amount and then the appeal will be admitted. That is not the case here. You file the appeal, file the stay petition with the assessing officer will reject the stay petition, then come to the tribunal saying that he has rejected the stay petition. Again, this rule also, one more thing you have to keep it in mind, says the quantum does not say the time. You can still ask the tribunal, give me 6 installments, 12 installments, 3 installments. That is not still given in the statute. You can still ask the tribunal that look at my financial situation, I have this difficulty. So give me 3 installments or 6 installments. That at least can still be done because this only focuses on the quantum, not on the timelines within this amount should be paid. But in a fit case, this could be a matter which will naturally be taken before the High Court or Supreme Court to challenge that this 20% quantum prescribed is arbitrary and it should be struck down. Similar to third proviso, where you said even if the delay is not attributable, the stay will still be vacated. Same principle should be applied to this 20% also. But from our perspective, what we need to understand at this stage is that if there is an appeal which you are filing to tribunal, and in the circumstances where you are filing to tribunal and the demand issue is there, First make an application to the assessing officer. File the appeal, make an application to the assessing officer that kindly stay the amount. Assessing officer may not stay in most of the cases. If he stays, very nice. If he doesn't stay, then come to the tribunal and file a petition. But 20% becomes minimum before the tribunal also. Even now, if you want to take the matter further, you will have to go to High Court. But one good thing in this is, there is an option of bank guarantee. Furnishes or, not and, or furnishes guarantee for the equal amount. You can furnish a guarantee for 20%. Quite few cases the tribunal has given bank guarantee, especially in covered cases, many of the cases they have given bank guarantee. See, what happens is, if you pay 20%, getting that 20% becomes difficult most of the times. Someone said me that department is like Tirupati Hundi. If you put, you don't get anything back. Bank guarantee, you will at least at the end of the period, you will cancel the bank guarantee, and at least you may not have to run post to pillar to get the money back. Anyway, that would be in each case, the situation would be different, one will have to take it again.
Once the IT disposes of the appeal and I file an appeal before the tribunal, I go to AO, ask for a stay, he rejects it, then I go back to PCIT.
No, you will have to come to tribunal because the matter is pending before tribunal.
I can't go to.
You can go to PCIT, PCIT will not entertain it because, see, when the appeal is pending before the tribunal, the power of stay is with the tribunal.
So if PCIT rejects, then I can file a writ.
You can file a writ, but
This mandatory payment will not be applicable.
you can take that route. That you can even do if the tribunal rejects and says you pay 20%, that you can even do it. Nothing stops you from doing it. PCIT may not even dispose your stay petition for 6 months. Tribunal will at least hear and dispose it in 7 days. So you will be faster to the High Court.
Is it not beneficial for me if it is not disposed as long as it is pending, then the AO cannot?
You cannot be sure of protection when it is pending before PCIT. If the AO goes and attaches the bank account, then you will be left with no option. Whereas once you file a stay petition to the tribunal, he cannot attach your bank account. If he attaches your bank account, you move to the tribunal immediately, he will have to vacate the bank account attachment next day. Because various decisions are there, I have also cited here that once the stay petition is pending before the tribunal, he can't attach your bank account or he cannot take any coercive action till the disposal of stay petition by the tribunal. So in a practice, these are all practical things. I mean, you'll have to judge it in each case what would be favorable to you. Now PCIT may be very good friend of yours, who knows. So in that case, maybe you go to PCIT and ensure that he just gives a call to the assessing officer that don't take any action in this case. So it depends on case to case, yeah.
Sir, even adjustment of refund is a coercive action.
It's a coercive action. There's a decision of UTI, Bombay High Court. When the stay was granted and still they adjusted the refund, they asked them to refund the amount. The citations are there on next page, Western agencies and other cases.
Can an application be made to AO to refund the amount?
You can make an application to A, you can move to the tribunal also, saying that this is what has happened and direction should be given to the AO to give the refund back.
Still the case is that CIT appeals.
The CIT appeals, you can't go to tribunal at all. See, if the appeal is pending before the CIT appeals, you can't file a stay petition to the tribunal. The 254(2)A would come into picture only if the tribunal, if the stay petition, if the main appeal is pending before the tribunal. If the main appeal is pending before the tribunal, you come to the tribunal for stay petition. If your main appeal is pending before the CIT appeals, file a stay petition to AO, then as per the instruction, go to the PCIT, and if PCIT rejects, go to the High Court.
The appeals commissioner has the power to stay.
They have, but given that the instructions, latest instruction says you file to the PCIT, it is better to file to PCIT because the instructions very clearly said PCIT has been given power to reduce that 20% in so and so circumstances. Less than that, he can give the merits. Okay. If you are filing to CIT appeals, one, disposal becomes difficult. PCIT, as per instruction, he has to go pass an order as per that. Okay. So ideal situation post the instruction of the department is AO, PCIT, if PSCI rejects, writ petition to the High Court. We have Karnataka High Court in Flipkart's case, which have said that if you file a stay petition to the PCIT, PCI should consider the merits of those cases, and they have given guidelines how he should dispose that particular stay petition. He has to follow that petition. Okay. I mean, if you ask legally whether I can file to CIT appeals, possible to file before CIT appeals, but practically it would be more, because of the instruction, it would be more fruitful to file it to the PCIT.
So you don't need to say, in such case, you have to file the stay application with the two people in case of CIT appeals?
No, first you file with the AO. If AO rejects, file it with PCIT. If AO accepts it, See, he says that okay, you pay 20% in 6 installment, you are fine with it. Then just follow that order. Now, if you are not fine with it, then you go to the PCIT asking for relief.
So what about the case where 20% is already paid?
Then he can't ask, if 20% is paid and matter is pending before whom?
CIT appeals.
Then he can't ask anything. Just say that 20% is failed, follow the instruction, grant the stay.
But they can continue with refund adjustments.
They are doing it, legally not permissible, but they are doing it. In a valid case, you could take it to the High Court. Yeah. So, see, refund adjustment is such that a new demand is created. Even if the refund is given, they will create a 220 demand and set off the refund. And it is like a black hole. You don't know what is happening inside that. So, that is another problem which is more of an administrative difficulty than a legal difficulty actually. So, they have to tighten up their systems to make it more workable. That is how it is, but anyway, unfortunately those things are there.
Even in the stay orders, you were expressly mentioning there that it will not apply to the refunds, subsequent refunds. So what is the reason?
So, you will have to take it to higher forum. If you think that it is a fit case, then you will have to take it wherever it is required. So, PCIT passes this order, take it to the High Court. So, the refund they are saying that we will set off the refund, subsequent refunds even if 20% is paid, that I accept. But given that they themselves have laid down the guidelines, and if it is a fit case, then in those cases you should see that it can be taken. Now, it will all depend on what is the quantum of demand, whether the assessor is willing to bear that additional litigation cost, all that. So, I mean these are all factual situation. In a particular case you will take a call. Some feel that okay, the refund is adjusted, it is fine, at least we will get 6% interest subsequently. So, right. So, I have given some cases also where refund, I mean where the application is pending, they cannot there. When the rectification is pending, this is Allahabad High Court decision cited on page 22, Sultan Fisheries. So, if you filed a rectification application, suppose the matter is pending before the CIT appeals, so you filed a rectification application, then this could be a useful decision that you first dispose my rectification application, then only you can enforce the demand. Okay. 5-10 minutes will take. Yeah. So, last part is 255. 255 is a rule of procedure. So 255.5 gives the power to frame the rules to the tribunal itself. So, if you see the 255.5, 255 deals with various things. One is constitution of benches, what is special bench, what is SMC, third member, all that is dealt in 255. Okay, 255.5 specifically says, subject to provision of the Act, the appellate tribunal shall have power to regulate its own procedure. It will have power to regulate its own procedure. That means it only will regulate. Someone else cannot come and interfere into the procedure. Okay, and the procedure of benches thereon in all matters arising out of exercise of its function, including places at which the benches shall hold their sittings. So, it is a power of regulating procedure, power to make rules related to procedure, which is given in 255. Naturally, 255 cannot override the substantive power of 254.1, where the powers are wide in terms of as it thinks fit. But in terms of procedure, the power is given, and the government authorities or someone else cannot interfere into the functioning into the tribunal. So, see now the government cannot say that they will transfer the members. The president has to transfer the members. The law secretary or the law ministry cannot say that this member should be posted at so and so benches. So, that power will vest with the president as per the rules, and that has to be taken as per the rules. SMC, as we said, so 255 also deals with SMC subsection 3, says that SMC will be a cases, again that will be allocated by the president or vice president of a particular location, where the total income is less than 50 lakh rupees. It will be heard by a single member judge. It will be bench of a single member will heard it. It is a total income of 50 lakh rupees, not necessarily addition. Addition doesn't matter here. What is the relevant aspect is whether the total income after the assessed by the assessing officer is less than 50 lakhs. Earlier it was 5 lakhs, then later on increase it to the 50 lakhs. So, sometimes if the small cases are posted before the single member cases also. 255.3 deals with both special bench also. Constitution of special bench will be with the president. President will notify that he is constituting those special bench. Vice president or zonal heads cannot constitute the special bench. So if you want to, the president will say that so and so issues are there, so and so members will be part of the special bench, and so question will be decided by the special bench. The special bench will only decide what question is posted before the special bench. It doesn't decide the appeal, it will decide the question. So in an appeal there may be numerous things, out of that one particular issue which may be before the special bench, and the special bench will then decide that particular matter itself, that particular question itself. So important questions of law will generally be posted on special bench. Especially this could be circumstances where two coordinate benches have taken contrary view and they want to have similarity on that particular matter, one, or it is really an important issue where a lot of appeals of similar nature are coming at before tribunal. So in those cases, the president may think fit to constitute a special bench, and where it will sit also the president will decide. Once the special bench is decided, it becomes binding on all the benches, all 63 benches of the tribunal has to follow that particular decision of the special bench. That is all covered in subsection 3. Subsection 4, 255 subsection 4 deals with third member cases. Very rare, but sometimes you may consider a third member cases. What is a third member case? Suppose there are now accountant member and judicial member, and you have argued the matter, but accountant member and judicial member do not have a same view, they have a different view. Then what happens? Then under 255(4), a reference can be made to third member by the president. So president will say that this particular issue, this is the opinion of accountant member, this is the opinion of judicial member, these are the difference point of view, and they will refer to the third member. Third member's jurisdiction is only that reference. Third member's jurisdiction is only that reference, what is coming to him. And only at that particular point of difference, he cannot come with his third view. He cannot come up with his third view. He has to take those two views and concur with which view he thinks is correct. And then the decision by majority will become the decision of the bench. So this is the concept of third member. Not very prevalent. Sometimes you will find a third member bench. Generally, you will find the decisions of accountant member, judicial member with a common view they can proceed with it. Then
Special bench order will not be on any specific assessee.
see, in a special bench, no doubt there will be a lead assessee and there will be interveners also. So if I have a similar issue, I can intervene in the special bench. In a normal bench, there won't be any interveners. The accountant member and judicial members will decide the particular cases. You can't hear a third party in a normal case. In a special bench, there will be a lead party, in which case the reference has been made. So the special bench will pass an order in that lead party. They will also hear the interveners and give a decision on the question of law. Then the special bench order will again be placed before the division bench, which is the normal bench. And division bench will pass a final order considering the special bench decision.
So when you have to go to the high court, you have to go for the normal order.
Normal order. Which naturally the special bench order also will be part of it. Because the special bench directions will get incorporated in the formal division bench order. Some practical things that change of name, change of address, you should file a revised form, rule 9A, you should follow it. You cannot just write a letter that this is changed. You ideally file, as per rule, you should file a new form 36 and change it. Respondent in your appeals should always be the assessing officer, not CIT appeals. Even if you file an appeal against the CIT appeals order, the respondent will always be the assessing officer. Many times we see that this mistake is made, but the respondent should always be the assessing officer. Yeah.
How about intimation order passed by the CPC?
There will be some assessing officer's name, no? Assistant Commissioner, CPC. He will become respondent. See, if you file an appeal to CIT appeals, there is one more important thing under 249, the undisputed tax should be paid for the appeal to be maintainable before the CIT appeals. That condition is not applicable in the context of the tribunal. That rule does not apply to the tribunal. Supreme Court's decision in Pawan Kumar Ladda's case.
So if CIT dismisses because of the non-payment of taxes, can we go to ITAT against the CIT order?
You can go to ITAT, but what will happen there is, before the ITAT, they will see whether the CIT's dismissal is correct or not. That they can adjudicate. So if you pay by then they can still send the matter back to the thing. So while filing the appeal to the tribunal, that condition is not applicable. But in such circumstances, the CIT appeals order, whether it is correct or not, will have to be seen in the light of circumstances prescribed in 249. That will be seen. Appeal can be sent in a registered post, but it should reach to the tribunal, rule 6, reach to the tribunal within that 60-day period. It is not your posting day, but the receipt date of tribunal which is relevant. And ideally, appeal should be filed on the place where the jurisdiction is there. But if it is a last day, you can file the appeal at other places also and then ask them to transfer this. You can also file appeal to the address, residential address of registrar or any member, assuming it is a last day of filing. That is there in order 1 of 1973, you can do that. No doubt, again, I am not suggesting to do that. But these are in practical situations, sometimes it may happen. You have forgotten that you have to file appeal in Panji and you are in Bangalore. So at least file it here, then ask them to transfer it to Panji. And that could be a safeguard in certain circumstances. No doubt I am not advising that, but there could be circumstances where this provision can be used. So this is broadly issues or topics I think I wanted to cover, and hope you all enjoyed the session and there is a value addition. Any questions we can take? Yeah.
In case of single members, like you said there are two members, there are two this one,
Judicial and accountant.
yeah, both will be there.
No, single will be, single, all members in a single member cases, there are notified members who can sit on single member. So either a judicial member or accountant member, one of them will sit in the single member cases. But generally the senior who have been notified, suddenly a new member will not be notified to sit on a single member cases. Either a judicial or an accountant member, that the respective vice president will decide who has to sit on the single member case. Yeah.
The limitation period expires on a national holiday or Sunday.
Next day you can take. General Clauses Act. Yeah.
In certain circumstances, can you ask the member to recuse himself or herself?
Possible.
Can they do it?
They can do it. They can do it. There are many cases where member will say I am an interested party in this because I might have handled this case earlier. Right? Suppose today you handle a case of X company and tomorrow you become a judge. There is some sort of feeling at least for you handling that case. So you can say I will not be a part of this. The other party may say that you should not be a part of this, and they recuse if they are interested. Many times we have seen the tribunal members themselves say that this is my relative's case or this is somewhere related to me and I don't want to hear this matter. That time you will see in the cause list that not before so and so judge. They will mention it and they will recuse it.
There is no interest but apprehension of bias.
How do you demonstrate that?
The apprehension should not be.
I mean that way you will do bench shopping. Right? You will do bench shopping that way. Okay. So what could be a bias? For example, there is before a special bench. Okay. And one of the members has already given a particular view. And can you make that member as a part of special bench? Now there can be apprehension of bias. There you can possibly say that look, this judge has already had a particular view. Okay. And now you are making part of him a special bench which has to decide by majority. Then there is a problem. Unfortunately, this would have been the correct position. The Supreme Courts in the Indore Development Authority, in the context of land laws, this matter was there before, I don't remember the judge's name, Arun Mishra. So it was there before him, and the advocates argued that look, you have already taken a view on this particular matter, so you cannot sit on this bench. It was a constitution bench of 5 members. But despite that, he said, I can hear it, and he heard it and passed the against order. That means he confirmed his own order. Now look at a person who has decided a particular issue in so and so manner. For him to reverse his own view and say his own order was wrong, he has to, if he sits on a special bench, he has to say his order was wrong, and then he has to reverse it. That could be an apprehension of bias. But apart from that, demonstrating anything else, just to say that there are malified intention of a judge, may be very difficult. At a practical level, may be very difficult. Legally, answer could be yes, but practically, how do you do it?
Can they impose cost?
They can impose. Rule very clearly says can impose at their discretion. I don't remember the rule, but rule very clearly says they can impose cost. And they do impose sometimes. If you ask adjournments again and again, they will say pay 1,000 rupees or 5,000 rupees to PM Relief Fund. They can do that.
So, is there any time limit for filing additional grounds?
There is no time limit. but practically do it as early as possible. No, after hearing you can't do it, no. First hearing you will have to take adjournment then. You go and take adjournment that I want to file an additional ground, this is the reason, please grant me adjournment, take the fresh date, file it before that. See, paper book, these additional grounds at least file 5 days in advance. 1 week is what the rule recommends. No doubt they don't press it that much, but that try to follow that as practical as possible. As possible do it.
Oral additional grounds or oral alternative grounds can be taken during the course of hearing.
Grounds move it. Arguments you can do it, but grounds you have to move in additional ground. It has to be written. See, what can be part of appeal memo? Only they can adjudicate on that. See, it could be oral supporting argument under Rule 27 of Income Tax Appellate Tribunal rule. Even if you have not filed an appeal, you can support the argument. Say revenue has appealed, so you can support it through an alternate argument by taking Rule 27's recourse. But if you want to file a ground, additional evidence, try and file a petition.
Is the tribunal bound to admit that ground or
If they reject, they have to give a reason why it reject. Suppose you take a ground, but there is no factual data related to that on the record. Then they will say, how do I adjudicate it? I am not accepting this ground. But if it is legal ground, say for example, we are challenging 143(2) notice is not issued, which is on record. Then they have to admit it by virtue of Supreme Court's decision in NTPC. They have to admit a legal ground.
So case or TF case, can it be subject matter of
MP. Kutch Saurashtra is against us.
Supporting documents can be submitted at a later point.
No, grounds, no doubt drafting I think is one of the sessions, but grounds has to be concise to the point that this is the grounds, that this is what I am aggrieved by the 37 disallowance. You are not supporting. So first you will file the appeal papers, which will be your grounds, relevant orders. These supporting documents will be part of paper book, Rule 18. And there is a procedure given how you will file a paper book. You have to index it, number it, you have to certify true copy, you have to say that this was certified that this was before the lower authorities, you have to certify that. If it was not before the lower authority, it has to go as additional evidence, Rule 29, right? So first you will file an appeal, you will get the appeal number, then file the paper book, whatever documents you want to rely on, file it part of a paper book. You want to file a submissions, case laws, file it. Indexing and numbering is also an important skill which you should keep it in mind, because it should be handy for the members to refer it when you say so that I want to rely on so and so page number. It should be there. It has to be, pagination has to be there, indexation has to be there, which will clearly spell out what are the documents on record.
158 AB, sir. Is there any practical application of this section, sir?
Deferment of appeal.
Yes, sir.
Currently, I have not seen anything.
Collegium is not constituted.
I think they constituted some time back. Some time back, I think some notification is there, not sure. See, old provision also, they practically hardly it was used. But maybe because of this, they may specifically do it.
What is the progress of the e-filing of appeal? ITAT?
They are doing some test runs, but not implemented everywhere. Faceless will not, as of now, nothing is there on. There is a provision naturally in the Act, but with the difficulties of faceless other way around, whether it will come for tribunal and whether tribunal can be made faceless, it's a court, right? It is not any authority, it's a court. I don't think it can be made faceless, it will not be constitutional valid. The day they may prescribe the rules, next day it will be challenged in Supreme Court and you will get the stay on third day.
The same assessment here, under two different sections, we have filed an appeal with CIT and they have objected. One of
Two different appeals in the sense?
One would be under 143(1) where CPC would be the jurisdiction
143(1) and 143(3).
on that basis. And at CIT appeals level, they would have rejected that for the same year two appeals have been filed. And one with rejecting the first appeal and second one where he is giving the, on these matters I am not able to admit your grounds or I am following rejecting your appeal. Now while making
You will have to file two tribunals, two appeals to tribunal.
today,
See, each order is a cause of action and it has to be legally reversed, either by a statutory provision, order of an higher authority, otherwise that demand or that stays. So 143(1) you have to go through the process. Either there has to be 154 reversing the demand, or you have to file an appeal. You can't sit silent on that. You'll have to file 2 appeals in those cases.
Is there any time limit for stay order? Getting orders?
See, what happens in stay petition is, it depends on whether the department or revenue is pushing you for payment. The orders, again practical experience, if the order is passed in April, May, the officer will generally not push for demand. They will push for demand in last few months when the budget collection targets have to be met. Right? So, in the first few months you just file a stay petition, it is there on the file, hardly we will see a disposal of that stay petition. Okay? Practically they may not dispose it. So, why go to tribunal at that point of time? You will see, that is a different issue, but again if you go to tribunal and they may ask you to pay 20% now. So, I mean, you have to see whether your adjustment is, how much is your adjustment.
If it is adjusted, then we can pay, we can subtract from the bank.
20, yes. Suppose your 100 rupees is the demand, 10 is adjusted, then you have to pay only 10. Yes.
Can you file an early hearing petition?
Before whom? See, ITAT hearings are coming so fast that you no need to file an early hearing petition. Seeking adjournment is difficult now. If you ask adjournment, next 2 weeks it will be posted again. So, there is no requirement of filing any early hearing petition. So, there is no requirement of early hearing. It used to be earlier, but now there is no requirement. I don't think in near future we will have that requirement. I don't know what happens 5 or 10 years down the line, but at least near future we won't have that requirement. Right? So, thank you everyone for patient hearing, and thank you KSCA for giving me this opportunity, and wonderful effort by the team planning this program. Thank you one and all.
Thank you, sir. I extend my heartily thanks to CA Narendra Kumar Jain for on behalf of our KCA as well as all the members present here for enlightening us with the litigations provision and as well as his experience. I request CA Vijay Kumar M. Patel to present him with a memento.
Thank you. Yes? Any other announcements?
I extend everyone my thanks to everyone present here as well as the mentors and the direct committee chairman and KCA president sir as well as secretary sir for organizing this program, and I request everyone to make sure that you attend the evening online session which will be shared in the WhatsApp group 4 to 6 p.m. without fail.